Okay, good morning, class. Today I'm going to give you your mocks. They're your final examinations. So I'm going to start off with 1 minute warm up, and it's 180 lit before your mock, okay? Here we go, 1 minute practice warm up. Mr. Speaker, I am very pleased today to introduce a bill to revise the Employment Economic Opportunity Act. My distinguished colleague and friend, Senator McDaniel Bryan of New Hampshire, is the current chairman of the Committee to Develop Employment Opportunities. I am also a member of this program and the Youth Employment Program. This bill would also authorize the establishment of bilingual educational programs for minority groups. Mr. Speaker, I have had a long personal involvement in and identification with our nation's war on poverty. Since 1969, I have worked on committees with 4 former presidents, Mr. Johnson, Mr. Nixon, Mr. Carter, and Mr. Reagan. The strategy that has always been used is to try and break the vicious cycle of poverty that is a hopeless web for many Americans. Like so many other problems that Congress must face, the problem of poverty is one that can only be broken with determination and a firm commitment to freeing the poor of America from discrimination, employment, and dependency. So hopefully you all have warmed up prior to listening to this. 180 lit, you have Mark Hill, Frank Young. And this is going to be your 180 lit number 1 for your mock for 5 minutes. Final exam. The defendant, Mark Hill, was convicted of 1 count of armed robbery and 1 count of attempted first-degree murder. The trial court signed an order denying his motion to modify the sentence, and from this order he now appeals. The facts of the case are as follows. The victim in this case was a truck operator who delivered soft drinks to various stores. While he was checking the rear door of his truck, he was approached by the defendant and another man identified as Frank Young. Each of them were carrying handguns. Young informed the victim that it was a holdup and demanded that he turn over any money he had. Young was standing at the victim's left side with his pistol pressed against the victim's chest. The defendant, in this case Mark Hill, was about 2 feet behind Young. The victim handed his wallet containing about $300 to Young, and who he then demanded more money from. The victim said that he had given them all he had, but Young insisted that the victim had more. At that point, the defendant told Young to shoot the victim. Young fired his pistol into the victim's left chest. The bullet exited his lower right side. As the 2 robbers began to run away, the defendant turned around and shot at the victim while the victim was kneeling. This shot apparently missed. The police apprehended both men a short time later in a garage about 2 blocks from the scene, and 2 guns were taken. The criminal complaint charged each man with 1 count of armed robbery and 1 count of attempted first-degree murder. Both defendants entered pleas of not guilty, but just prior to trial, Frank Young requested permission to plead guilty to both counts. As part of the plea bargain, the state said it would make no recommendation as to the length of sentence. The court accepted his 2 pleas of guilty, but put off sentencing him. The trial then proceeded against Mark Hill. The jury found him guilty on both counts, and the court imposed sentences of 25 years on each count to run consecutively. The trial court then sentenced Young to 25 years in prison on each count, but stayed the prison term on the armed robbery count and ordered probation. 2 issues are presented for review. First, did the trial court deny the defendant equal protection of the law by giving Frank Young a lesser sentence? And second, did the trial court give Mark Hill an excessive sentence? The defendant asserts that the trial judge improperly punished him because he exercised his right to a jury trial. He cites the fact that the trial judge sentenced him to a total of 50 years in prison, but sentenced Frank Young to only 25 years in prison. The defendant's claim is based upon the rule of law that he may not receive a harsher sentence solely because he availed himself of his legal right to a jury trial. The court has ruled in the past that a mere disparity between sentences falls short of establishing that the trial court has punished a defendant for demanding his or her right to a jury trial. While equal protection of the law requires a similar sentence for a similar case history, it does not preclude a different sentence for a person who has been convicted of the same crime based on his or her past criminal record. The length of the term is to be left to the sound discretion of the trial judge. There can be no denial of equal protection of the law unless the trial judge abuses that discretion. The record shows that the difference in this case was the result of the trial judge's attention to things that were relevant to the sentencing procedure. The trial judge referred to Mark Hill's attitude. The judge said that the defendant was arrogant and violent right up to the time he walked out of the courtroom. On the other hand, Frank Young showed remorse, was cooperative, and willing to take the stand. Mark Hill contends that when the trial judge sentenced Frank Young, it was improper for the judge to take into consideration the fact that Young had entered a plea of guilty and was willing to testify. Mark Hill argues that a plea of guilty should not be a factor in giving a lenient sentence. He argues that he was punished for demanding his right to a jury trial if the judge did consider Young's plea of guilty. It does not follow, however, that where a trial judge makes a comment about a guilty plea as a consideration in granting a light sentence, he is punishing the person who asks for a trial. This court has held that a plea of guilty is the first step toward rehabilitation. As we view the record, the trial judge thought that Frank Young's guilty plea and his desire to testify showed contrition for his crime. We hold that the trial judge's consideration of Young's guilty plea was proper and relevant. We can distinguish the case at bar from the case that Mark Hill cites. In that case, the trial judge flatly stated that he would not consider probation for a defendant who pleads not guilty and demands a trial. In addition, the record in that case shows that accomplices were culpable. And then we have 1 minute at 200 jury charge. Okay, this is 1 minute practice, 200 jury charge. The jury has returned. In response to the question from the foreman and considering that definition of assault with intent to commit murder, we will clarify wrongful act and attempt was unlawful. I am going to read to you the legislative definition of assault from the Penal Code. The Bar Review Committee has included some other words that probably created some of this confusion. Assault is an unlawful attempt coupled with a present ability to commit a violent injury upon the person of another. You can see in this printed instruction that they were submitted to the jury and are made available to the jury during their deliberations. We have added to commit a wrongful act means that by physical force instead of to commit a violent injury. When you have an assault, what it really means is that you intend to strike, hit, shoot, or knife another person. In other words, you intend to commit a battery. I am not getting too historical or academic in my next comment, hopefully, but one of the cases that most law students read, at least I read it back in the late 60s when I was attending law school, is a case from England. And then you have on your 200 jury charge, capitalized court when you can replace judge in the sentence, and that's it. Let me just make sure there isn't anything else. This will be 200 jury charge for 5 minutes for your mock, first but one final exam. Members of the jury, now that you have heard the evidence and the argument, the time has come to instruct you as to the law governing this case. Although you as jurors are the sole judges of the facts, you are duty-bound to follow the law as stated in the instructions of the court, and to apply the law so given to the facts as you find them from the evidence before you. You are not to single out one instruction alone as stating the law, but must consider the instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your sworn duty to base a verdict upon any other view of the law than that given in the instructions of the court. You have been chosen and sworn as jurors in this case to try the issues of fact presented by the allegations of the indictment and the denial made by the not guilty plea of the accused. You are to perform this duty without bias or prejudice as to any party. The law does not permit jurors to be governed by sympathy, prejudice, or public opinion. The accused and the public expect that you will carefully and impartially consider all the evidence, follow the law as stated by the court, and reach a just verdict regardless of the consequences. The law presumes a defendant to be innocent of a crime. So a defendant, although accused, begins the trial with a clean slate with no evidence against him. and the law permits nothing but legal evidence presented before the jury to be considered in support of any charge against the accused. So, the presumption of innocence alone is sufficient to acquit a defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt from all of the evidence in the case. A reasonable doubt is a real doubt based upon reason and common sense after careful and impartial consideration of all the evidence in the case. Proof beyond a reasonable doubt, therefore, is proof of such a convincing character that you would be willing to rely and act upon it without hesitation in the most important of your own affairs. If you are convinced that the accused has been proved guilty beyond a reasonable doubt, say so. If you are not convinced, say so. The indictment or formal charge against a defendant is not evidence of guilt. The law does not impose upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence at all. Likewise, the law does not compel a defendant in a criminal case to take the witness stand and testify, and no presumption of guilt may be raised and no inference of any kind may be drawn from the election of a defendant not to testify. The government has the burden of proving him guilty beyond a reasonable doubt, and if it fails to do so, you must acquit him. Any evidence as to which an objection was sustained by the court or any evidence ordered stricken by the court must be entirely disregarded. The jury will remember that a defendant is never to be convicted on mere suspicion or conjecture. A defendant may be proved guilty by either direct or circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. It requires only that the jury, after weighing all the evidence, must be convinced of the guilt of the defendant beyond a reasonable doubt before he can be convicted. While you should consider only the evidence in the case, you are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience. In other words, you may make deductions and reach conclusions which reason and common sense lead you to draw from the facts which have been established by the testimony and evidence in the case. You, as jurors, are the sole judges of the credibility of the witnesses and the weight their testimony deserves. You should carefully scrutinize the testimony given the circumstances under which each witness testified and every manner in evidence which tends to indicate whether the witness is worthy of belief. Consider each witness's intelligence, motive, and state of mind and demeanor and manner while on the stand. Consider the witness's ability to observe the matters as to which he has testified and whether he impresses you as having an accurate recollection of these matters. Consider also any relation each witness may bear to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause the jury to discredit such testimony. Two or more persons witnessing an incident or a transaction may see or hear it differently, and innocent misrecollections like failure of recollection is not an uncommon experience. In weighing the effect of a discrepancy, consider whether it pertains to a matter of importance or an unimportant detail and whether the discrepancy results from innocent error or willful falsehood. If you find the presumption of truthfulness to be outweighed as to any witness, you will give the testimony of that witness such credibility, if any, as you may think it deserves. If it is oddly within the power of either the prosecution or the defense to produce and then we'll get ready for your Q&A. 1 minute first, okay? That's okay. We started a little late.
Is anybody else?
Mm-mm. Okay, let me see. And it starts with Sheila. Okay, this is 1 minute at 2:25 Q&A. Okay, then what happened after that? You were taken to the hospital?
Well, I had to wait until the manager came and his employees came, and we had to call the ambulance. I sat there for 10 minutes. I heard them calling 911.
What transpired at the hospital? What kind of care did they give you?
Well, emergency was very slow because the doctor had to come from Houston. He came and set my leg, and I had a fiberglass cast up to my groin right here. It was a big cast, but not too heavy, you see.
Did he put you to sleep to do that?
No, it was with a shot.
Okay, no anesthetic. You were sedated then.
Well, of course, it hurt a lot. I had a lot of pain.
Right. Then you were in the hospital for a while.
I was only there 2.5 days, simply because my husband was an invalid at home. He needed me at home to help take care of him.
Okay, right.
And I had to be back to oversee care for him. I oversee the nurse.
And what hospital were you in?
Moss Valley in Blade City.
Okay, so what happened after that? You were in the hospital a couple of days after you broke your, and then you have on your 225 Q&A, you have for the mock, Officer Lamar, Melbourne, Officer Butler, West Melbourne, Butlers, Bob Jones, Northland, Beale Post, State Peace Officer, Standard Training, TT Sheriff's Academy, South Lake Police Academy, Sheriff's Academy in South Lake. And Peace Officer is PAUFR. Okay, and this is going to be first 225 Q&A for 5 minutes. Then it starts in the middle. Officer Lamar, how much tenure do you have on the job?
5 years roughly.
5 years. And how old are you?
I am 28. My birthday was last Thursday.
Happy birthday.
Thanks.
Thank you. I'm here to speak with you in regards to an accident that occurred in your city, which was a fresh pursuit that started in Melbourne and crossed over into your jurisdiction. Are you familiar with that accident?
Yes, I am.
Are you the investigating officer for that accident?
I am.
Did the accident include a Melbourne police officer?
Yes, it did.
And he was the officer in full pursuit.
That's correct.
Okay, in regards to that accident, did you personally make out this traffic accident report?
I did.
Did you have a partner?
No, I didn't.
Were there any Melbourne officers at the scene of the accident other than yourself and Officer Butler?
Melbourne police officers or West Melbourne officers?
Melbourne police officers.
There were, but I don't recall who they were. They had a supervisor there, and there were several units there at the scene. I don't recall exact numbers of units that responded to the scene of the accident. Usually, initial responders number 4 units, plus support personnel.
Okay, can you tell me what you observed when you first arrived on the scene? In other words, did you hear the pursuit taking place?
No.
Did you get a radio call regarding this?
Yes, there were other West Melbourne units on the scene also prior to my arrival, prior to my getting there. More or less a cold scene by the time I got there. It was my area, so I dispatched to take the report.
Continue, Officer Lamar.
It's been quite a while. The only thing I really recall is as I pulled up and Butler's vehicle was heavily damaged. It was just south of the intersection in the southbound lanes. It had apparently collided with a pole from what I observed.
I see. Do you remember any of the specifics being related to you prior to and up to the point of impact, or any other information that was relevant?
There were skids, if that's what you're talking about. I don't know.
Well, I wasn't referring just to the skids. What I had in mind was what happened prior. The report says that the officer was in pursuit of a motorcycle, I believe, and the motorcycle was never caught. Is that correct?
That's correct.
Were there 2 motorcycles? Do you know?
You know, now that you mention it, it seems to me that they originally started out with 2, but I think at the time of the accident, he was chasing 1 motorcycle, as we later determined.
I see. Let's see. There was a female driver listed as party 1. Was her car hit at all?
I don't believe it was. No, it was not hit.
The skids, according to your report, listed, I believe, approximately 244 to 248 feet of 4-wheel locked skids by the police vehicle prior to impact. Is that correct?
Yes, that's correct.
Okay. Did you put any particular skid information on a speed computer of any kind?
No, I didn't.
Well, on a to-scale diagram, this would be to scale. The skids had to start 123 feet north of the intersection. Do you recall that?
Looking at this, I didn't do the diagram. It was done by another officer.
I see. Do you know who he was? What's his name?
Yes, Bob Jones.
Is he an officer at this department?
No, he works for the sheriff's department now, down at the county jail. He was an officer here at that time.
When did he leave here?
He's been gone just over a year.
And he's downtown at the county jail now.
Yeah, he's pending a transfer to Northland within the next few weeks, I guess. Or Beale, I'm sorry, he is going to Beale.
That's a pretty rough city now. I know they lost their own police department a while back and the sheriff has to patrol their city now. Moving onward here, do you have a police computer skid chart in the station here?
As far as having a computer or a formula that's available to, patrol officers, we don't. Other than perhaps the traffic template from Northland. That's the closest thing I have to that.
Do the officers in this department, are they subject to post certificates?
Yes.
From the state? Is that peace officer standard training?
Yes, that's right.
Where do the officers from this station get their training? What is their basic training unit?
Mine was the TT Sheriff's Academy, but we get a lot of laterals here. The main two are the Sheriff's Academy and South Lake Police Academy. But we've got people from all over, I presume, who went through the Sheriff's Academy.
Do you know by chance what Melbourne uses for their training? Which academy do they use?
I believe they use the Sheriff's Academy and South Lake too, but I'm not too sure. They may not be using the Sheriff's Academy now. I have heard some rumors that training would be through another academy.
Do you recall what the speed limit is for an emergency vehicle in your training?
Well, within the lights and siren activated?
Yes, with lights and siren.
The speed which is reasonable and cautious, and reasonable is due to the surrounding circumstances. You have to take in road conditions, traffic patterns, any obstacles, and the weather. All these factor into using reasonable speed with care and caution.
Is there a maximum stated by the code?
No.
Okay. In regards to this report, did you suggest that party one be cited for any particular violation of the code?
No, I didn't.
Do you believe she should be?
You're just asking for my opinion? Let me clarify that.
Yes, that's all I want, is your opinion.
Yeah, in my opinion, I don't think she should be cited in court, but I think that she was at fault. I think she made a wrong decision in proceeding through the intersection since she told me she had already heard the lights and sirens and seen it all coming, seen the police car coming. If she would have stayed put, I think that would have avoided the problem altogether. There would have been no accident.
Didn't she tell you that she had already gone into the intersection before she noted the emergency vehicle approaching?
She had started into the intersection, but she wasn't blocking the intersection, is what she said, and what the...
Okay, you also, that concludes your first minute, or your first mock. Okay, we're gonna go into your second mock, so I'm gonna break up the file. Do you want to take this, Michelle? Since this is the one. Okay. Okay. Take you that. Okay. Okay. Thank you, Michelle. Okay, so now we're going to start your second mock, and let me see. We have 1 minute at 180. Practice. Final exam. Okay. This is 1 minute at 180 lit. Practice before your mock. Your Honor, at this time I would like to read into the record the report that has been prepared by Dr. Lane. This report was submitted along with various other documents to be used as evidence in this case. The report reads as follows. On July 24, 1988, Thomas Crandall came to my office. I examined Mr. Crandall and performed several tests on him. This patient is 20 years old. He is 6 feet tall and weighs approximately 180 pounds. This patient was employed as a pipe winder at Hillshire Brothers, Inc. His former employment history included working at jobs that were similar in nature. He started working for Hillshire Brothers, Inc. in May of 1987. The date of his injury was October 7, 1987. This also was his last day of employment at Hillshire Brothers, Inc. In his work, Mr. Crandall sets a power drill bit into a freestanding machine. He then runs fiberglass through a liquid resin. The resin is in the past and it has been used as polyester, but in recent weeks, he has been working with, and then 180 lit for your mock. Proper names you have Mr. Phillips, James, Purdy, Burles, Percipient, Sherman, Virgil, Swat. And this is going to be 180 lit for your mock number 2 for 5 minutes. Your Honor, Mr. Phillips, ladies and gentlemen, I am very anxious to get started this morning and argue my case. Looking back, I may have even started arguing during my opening statement. It has been over a month since we had our opening statements. A lot of evidence has been presented to you by both sides during that time. We have listened to the testimony offered by the people, and you have heard the testimony offered by the defense. We are now finally to the point where we can discuss the facts of the case. We can discuss how the facts were presented and try to interpret the testimony that has been offered pertaining to those facts. Each witness has perceived the situation differently, and those individual perceptions must be weighed and evaluated to determine which version is closer to the truth. According to my watch, we only have 10 minutes before the lunch break. I am not going to try to make my whole presentation in that short period of time. If Your Honor will permit me, I will attempt to get started at this time and continue after the lunch and recess. As you will remember, before the evidence was presented, each of the attorneys, myself included, had the opportunity to present some salient points that we expected to establish during the course of the trial. I also took the opportunity at that time to address some of the negative aspects of my case so that the jury would have a clear picture of what I intended to prove by the evidence. During my opening remarks, I addressed 4 areas of concern. These 4 areas were highlighted in my notes as areas that would be very important in this trial, and my hunch was correct. At that time, I urged everyone to pay particular attention to those 4 areas when the testimony came in on that subject matter. I felt that they were the keys to solving certain issues in this particular case. I noticed that the judge is motioning for us to take our lunch and recess. I will continue with my argument this afternoon. Ladies and gentlemen of the jury, we are back from our lunch and recess, and I will try to continue where I left off. If there are any areas that you would like me to recapitulate, please let me know. We were discussing the 4 areas of concern that were originally introduced to you during my opening remarks. This case is much like a jigsaw puzzle, where we are attempting to fit all of the parts together into one coherent picture. I think the descriptions I have used to describe the circumstances in this case are very noteworthy. In a lawsuit of this magnitude with so many witnesses, so much evidence, so many things happening, and so many different agencies involved, I think the jury needs some guidance in determining and weighing the importance of the evidence that has been presented. I would now like to go over the 4 areas of concern that I have identified for you previously. Number 1, was there a person with a gun standing behind James assisting him in taking the keys away from Sherman? You have heard testimony given on this subject by an eyewitness. The point of evidence that was brought out proves beyond a reasonable doubt that James felt coerced or forced to take the keys away from Sherman. He felt threatened in some way. Number 2, did Purdy and James draw their weapons before seeing the shotgun on Burrell's lap? Evidence has been presented that says that their weapons were already drawn. The question for the jury is, can we believe the testimony of a percipient witness who has some interest in the outcome of this trial? Purdy had his gun out when the keys were taken away from Sherman. When James felt threatened, he also withdrew his gun. The case in point is whether he was at such an angle that he could see the gun on Burrell's lap. There had been conflicting testimony offered on that subject. The street light was on at that time, but the angle of the shadows may have prohibited James from seeing the shotgun. James's testimony does not shed any light on this subject. Number 3, did Virgil communicate in a loud and clear manner to James that he was a police officer when he came running up behind him? There were 14 officers who took part in this stakeout. 4 officers from the city, 2 officers from the county, 4 officers from neighboring communities, and 4 members of the SWAT team. All of the officers were hidden from view. Their cars were parked in an adjacent warehouse lot, not visible from the point of confrontation and the shootout. None of the witnesses have testified that they heard a police warning call given. Number 4, did James surrender to the police before he could reasonably have seen that there were squad cars and policemen at the scene? The question that came up during the testimony is, how could James surrender if he wasn't aware that he was surrounded by the police? Did he surrender when he threw himself on the ground, or was he merely trying to protect himself from gunfire? These questions were posed to the witnesses after carefully evaluating and weighing the testimony of, and then we have 1 minute warm up at 200 jury charge for your final. Your Honor, for the record, all parties are present. Both counsel are now present in the courtroom. The trial jury is present. The clerk has notified us that he has 3 separate questions that the jury has submitted for clarification. For the jury's information, I will indicate at this time that all of the CalGIC numbers are noted on each page. They are in the top left-hand corner, printed in red ink on each individual sheet of paper. First, let's deal with the matter of clarification of instructions. When conclusions are drawn from circumstantial evidence, the instructions mention the term reasonable interpretation. The question that the jury has propounded is reasonable by whose standards? This specific question refers to CalGIC 3.92. Specifically, this will be found in subsections A and B. In response to this question, reasonable by whose standards, the court will first define the word reasonable. Reasonable means amenable, sensible, and not subject to extremes. The jury should remember that reasonableness is judged only by the standards established by the jury and no other standards. Reasonableness is not established by any particular segment of society. Members of the jury, my comments at the conclusion. And then you have your jury charge. Proper names that come out, capitalized court when you can replace judge in the sentence. You have Oscar Mullen, Bruce Nixon, Harley Bennett, penal code. And this is going to be 5 minutes, 200 mock jury charge, okay? Here we go. Ladies and gentlemen of the jury, the court would now like to give you a few instructions that will guide you in your deliberations in this case. First of all, the law says that to reduce an intentional and felonious homicide from the offense of murder to manslaughter, certain facts must be considered and analyzed. If the manslaughter took place upon the ground of sudden quarrel or heat of passion, such provocation must be of such character and degree that would naturally excite and arouse passion in an ordinary person under similar circumstances. Provocation is defined in the dictionary as something that tends to arouse anger or thoughts of anger. Provocation means to irritate, stir up, or evoke. You must ask yourself the question whether or not sufficient provocation existed in this case to evoke the act of violence upon another. In the jury instructions, we come upon the term heat of passion. Heat of passion is defined as such passion as would naturally be aroused in the mind of an ordinarily reasonable person of average disposition confronted with the same or similar circumstances as those in question. Heat of passion is passion such as would cause a person to act rashly and without reflection and deliberation. Heat of passion is passion such as would cause a person to act out emotionally rather than using sound judgment. Ladies and gentlemen of the jury, what this instruction means is that a defendant cannot set up his own standards by which you are to judge him. The laws of society set up the standards by which you judge the defendant and his actions after you have carefully evaluated the testimony and weighed the evidence. If a person is quick-tempered and is confronted with some form of provocation that leads him to believe that self-defense is necessary, it is not the defendant's standards by which you are to judge him. You are to judge the defendant by the standards by which an ordinary person would do under the same or similar circumstances. The court will tell you throughout the instructions that you must abide by the jury instructions. You must remember that if there was a provocation that was of such a nature that was not calculated to naturally arouse passion and an unlawful killing of a human being occurs following such a provocation and the killing has all the elements of murder, then the mere fact of slight or remote provocation will not reduce the offense from murder to manslaughter. The provocation must be clear-cut and defined prior to your consideration of the evidence while you are in the jury room. The provocation cannot be slight or remote, but must be definite. You have heard several weeks of argument by the attorneys for both sides in this case. The evidence will show that Oscar Mullen reached for the knife. While reaching for the knife, he suddenly felt threatened. When you are threatened, you may feel the emotion of fear. You may feel that your life is in danger. You may feel that you are being menaced. You may feel distressed. This act of reaching for the knife by Oscar Mullen caused provocation on the part of Bruce Nixon. Suddenly there is a quarrel, a fight erupts. a heat of passion takes over. There was no time for Oscar Mullen to premeditate and deliberate his act. He can't be guilty of murder because of the circumstances surrounding this event. The evidence will further show that Harley Bennett cannot be found guilty of murder as an aider or an abettor. If you follow along with the instructions given in the penal code, this line of logic says that the aider and abettor theory is not applicable. Harley Bennett's role in this crime does not fit the court's definition of an aider or an abettor. Ladies and gentlemen of the jury, if it is our contention that there was no heat of passion, the evidence will show that there was a distinct element of fear in the mind of Oscar Mullen. He was afraid of the unknown. He did not know what was going to confront him in that dark alley. He was acting purely on instinct. The next instruction says that neither the emotion of fear in and of itself nor the emotion for revenge in and of itself toward another constitutes the heat of passion referred to in the law. Heat of passion has been defined for you. Nowhere in that definition does the word appear. Fear is defined as a sense of anxiety and agitation caused by the presence or immediate nearness of danger or evil or pain. Fear is a feeling of uneasiness, a cause for concern. You must ask yourself if you recognize the emotion of fear as being present when this act took place. You must examine the testimony of each witness carefully. Revenge is defined as a desire to inflict damage, injury, or punishment on another, a desire to seek vengeance on the person of another. You must ask yourself if you recognize the act of revenge as being present when this act took place. Again, you must examine the testimony that has been given by each witness. You must look at the testimony and determine whether or not a motive was present on the part of Oscar Mullen. The court has instructed you that you can have a combination of heat of passion, fear, revenge, and provocation. You can have a combination of all four of them. The court has instructed you that you must have one of them, all of them. You, as the jury, must decide whether or not any of these elements existed in the mind of Oscar Mullen on the night of July 10. Ladies and gentlemen of the jury, you will now retire to the jury room to select one of your number to act as foreman of the jury. The foreman will preside over your, and then we have Q&A. Michelle, you push the button, the recorder for the 1 minute, right? Q&A? Yes. Oh, okay. Didn't beep when I turned it off, so I was like, oh my. Okay, this is going to be 1 minute at 2:25 Q&A. Detective Danahue, what is your age, please?
39.
You are a detective with the County Police Department?
Yes, I am.
And how long have you been a police officer?
9.5 years.
And how long have you been a detective?
Since 1973, February.
Since February of 1973. Were you a detective then in December of 73?
Yes, sir.
Were you assigned originally to the 1973 and subsequent years investigation of this case?
Not full-time, no, sir.
Well, was there any other detective who was investigating it other than you?
Detective Bowman was, and Detective Whittle.
All right, were you working together?
Detective Bowman and I did, and then Detective Whittle took it over later on.
He took it over in 76.
Yes, sir.
Now, Detective Danahue, did you respond to the scene of the Turner residence on December the 11th? I'm sorry, on December 12th.
Yes, sir, I did.
When did you get there?
Approximately 4:15 in the morning.
4:15 a.m.
Yes, sir.
And when you arrived there, what, if anything, did you find?
I was met at the front door of the Turner residence by Officer Bolton, who was with our department at that time. And as I entered through the front door, I observed that some lamps lying on the floor.
And then you have your 225 Q&A. You have proper names: George Martin, Mr. Martin, Park Avenue, Dallas, Ford, Taurus, and Dodge. And this is going to be 225 Q&A for 5 minutes. And it starts at the very beginning, okay? Please state your full name for the members of the jury.
George Martin.
Mr. Martin, do you understand that I'm going to be asking you some questions about an accident that happened last July?
Yes, ma'am, I do.
First, I need to get some information about your personal history and background if I could.
All right.
Mr. Martin, are you married or single at the present time?
I am presently married.
How long have you been married?
I have been married for 29 years. It will be 30 in December.
Do you and your wife have any children?
We have 7 children and 10 grandchildren.
Do any of the children reside with you at the present time?
No, all of our children are grown and scattered throughout the country.
Mr. Martin, where do you and your wife reside at the present time?
We currently live at 1310 Park Avenue.
I believe that is located within the city limits of Dallas. Is that correct?
That's correct. The house and the neighborhood are both new.
Approximately how long have you lived there?
We bought the house and moved in 3 weeks ago.
Were you living in Dallas before that?
That's correct. We have always lived in Dallas.
Mr. Martin, what type of work are you presently engaged in?
I am presently engaged in living a life of leisure. I retired late last year.
What kind of work were you doing before your retirement?
I was a manager in a local department store.
Can you tell us what your job description was?
I had to supervise all of the employees in the store and work with the outside suppliers.
How many employees were working at this particular store?
At the time I retired, there were about 50 employees.
How long have you been employed as a manager with this company?
I was at this location for 13 years, but I was with the company for 25 years.
Have you always been a manager, or did you hold other positions in the store?
I started out as an assistant manager when I graduated from college.
What kind of degree did you receive from college?
I received a degree in finance.
Do you have any health problems that you know of?
I don't think so.
Are you taking any kind of drugs at the present time?
I take vitamins, but nothing more than that.
Were you under the care of a doctor or taking any prescribed medication at the time of the accident?
No, not that I recall.
Is it possible that you were taking medication at that time?
No, I was in perfect health at that time, and I am today also.
Do you remember the day of the accident and what you did that day?
I remember the accident and pretty much everything that happened, yes.
What time of day did the accident happen?
It was about 3 in the afternoon.
Do you recall where you were going at the time of the accident?
My wife and I were shopping at the department store.
Had you finished shopping previously, or is that where you were going?
We had lunch together and we were leaving to go to the department store.
Do you remember where you had lunch?
It was a little sandwich shop, but I don't remember the name of the location.
What kind of vehicle were you driving on the day of the accident?
I was driving a Ford Taurus.
Do you remember what kind of vehicle the other driver was in?
I sure do. He was in a Dodge pickup.
Do you happen to remember what color the pickup was?
If I remember correctly, it was a black pickup.
Was there anything distinctive about the pickup as you remember it?
It had very large wheels, but that's the only thing I would call distinctive.
Approximately where was the pickup when you first saw it?
It was backing out of a driveway as we were driving down the street.
Was this the driveway of a business or a residence?
It was a house. There were no businesses in that area.
How fast were you driving at the time of the accident?
I was going around 30 miles an hour.
Do you know what the speed limit is on that particular roadway?
If I remember right, the speed limit is 30 in that location.
You said previously that the vehicle was backing out of the driveway. Explain to us what happened next.
I hit the pickup right on the back bumper.
Were you applying your brakes immediately before the impact?
I barely had time to hit my brakes, but I recall that I did.
How do you know you actually applied your brakes, Mr. Martin?
After the officer arrived, he measured the skid marks.
Do you recall how many feet of skid marks you left?
I believe the officer said there were about 10 to 15 feet.
Mr. Martin, who else was riding in your vehicle prior to the impact?
My wife and I were the only occupants in the vehicle.
Did you sustain any injuries in this accident?
I cracked a few ribs on the steering wheel and was sore for a week.
Was your wife injured in the accident?
Yes, she injured her neck because of the sudden impact.
Do you know if anyone in the pickup was injured at all?
I don't believe the driver of the truck was hurt.
Was the driver the only person in the vehicle at that time?
That's correct. There were no other passengers.
Did you get out of the car immediately after the accident happened?
I initially had the wind knocked out of me, so I was just sitting in the vehicle.
Did the driver of the pickup get out of his vehicle?
Yes, he was a young man and he immediately ran over to check on us.
Did the other driver say anything regarding the accident or how it happened?
He said he was sorry, but he did not see us coming.
Mr. Martin, were your brakes working properly before the accident happened?
Yes, my car had just been serviced about 5 weeks before the accident.
Did you service the vehicle or did you pay someone else to do that?
I always take the car back to the dealer to have the maintenance work done.
Mr. Martin, do you own a cellular phone?
No, I never have.
The police report mentioned something about a cell phone. Do you know why he wrote that?
Yes, the driver of the truck was talking on his cell phone while he was backing out of the driveway.
Did you personally see this?
He told us immediately after the accident.
Okay, you all, so that concludes your mocks. Type them up before the deadline of Wednesday at midnight and register on time for your class, okay? Let me know if you have any questions regarding your grades or anything. Have a great day and practice and stay on your machines.